It's the fourth time I've been here. I appreciate you having me back. First time in about 4 years. All right, so we're talking about the related fields that come into play with estate planning and elder law. And there's three main areas when people come to see me. They say, I got to avoid probate, because if I avoid probate, I'll avoid estate taxes. And if I avoid estate taxes, I'll avoid nursing home costs. All right, so it's all jangled up in their minds. All right, there is some connection between those things, but they're basically different things. So let's take a look at each area separately. People come to me. I got to avoid probate. I got to avoid probate. I say, oh, that's good. I said, what's probate? I don't know. I just know I got to avoid it. Okay. So let me throw it out to the audience. What's probate? Anybody got any ideas?
Going to court.
Going to court is often involved. Actually, it's almost always involved. Right?
It's expensive and it takes years.
It's expensive and it can take years.
It's something where there is no beneficiary.
The judge decides, or the court decides how your assets are dispersed.
Okay, that can be the case in a certain type of probate.
Time consuming.
Well,
Time consuming? Okay, this gentleman was actually very close here. But if you take away nothing else from today, in 25 words or less, here's what probate is. Probate is anything that you die alone with in your name has to get to whoever or whatever you want to get it to, okay? It's anything that you die alone with in your name. It's not whether you have a will or you don't have a will. It's certainly better to have a will than not have a will. It's whatever you have that you die alone with in your name, okay? In reality, most of your assets don't pass by probate. They pass by other methods. Can anybody suggest a method of how other assets may pass?
Joint tenancy.
Joint tenancy is one.
beneficiaries.
Trust. All right, so we got all three. All right. Basically, joint accounts. If you have a joint account with somebody, it doesn't go through probate. Why? It goes to the other surviving joint owner or owners. If you have beneficiaries, a named beneficiary on a life insurance policy or an IRA, it doesn't go through probate, it goes to the named beneficiary. Or if you have a trust and you actually fund the trust, if the asset's in the trust. A lot of times people have trusts and they don't put anything in it. But if you deed your house to a trust, for example, and you die, it doesn't go through probate because it's not in your name alone, it's in the name of the trust. So those are three methods that things don't pass out, that things pass outside of probate.
What about funding the trust with the will? Provisions in the will.
You could have a will that funds a trust. You would still go through probate if it's not in the trust because you have to get the executor nominated. All right? But let's take a look at each one of those methods because I want to mention a caveat in each area. All right? If you have a joint account, all right, and you have it with a spouse, you're protected because each spouse protects each other unless they have a joint creditor. All right? Anybody have accounts? I shouldn't ask this way. Anybody have accounts with a kid as a joint owner? All right? Not a great thing to do. If they're a joint owner, they have a joint current interest. So for example, if a kid has a creditor, those funds are entirely available to the creditor. All right? A much better way to hold an account with a child is what's called a TOD or a POD account. It's called transfer on death or payable upon death. All right? And a lot of times you'll see these things, Joe Smith in trust for Jaden Smith. All right? All that means is that when Joe Smith passes away, it automatically goes to his beneficiary. So on a joint account, the caveat is always better to have the kid on as a TOD or a POD holder and not a joint owner. Okay?
You set up the account that way? TOD or TOD?
Yeah, you can set up the account. Can you set up the account that way? You go to the bank and you say, hey, I want this account. I want my son on as a future owner. I don't want him on as a current owner. And they set it up with a card. Okay? Somebody mentioned beneficiaries. Now, a lot of stuff, IRAs in particular and life insurance policies, pass to named beneficiaries. All right? Which is usually pretty good, but here's some caveats on that. All right? Do people check their beneficiary designations every 3 to 5 years? All right, because what tends to happen is you set something up, an IRA or a life insurance policy 30 years ago, turns out your beneficiary has passed away, and therefore there's no beneficiary, guess what? Your name alone goes through probate. Or your beneficiary is your son, who you haven't spoken to in 30 years. Guess who's going to get the money? Your son, who hasn't spoken to in 30 years. So I always advise people to check their beneficiaries, make sure, number one, they're still there, and number two, they're the ones that they want. My own brother, about a year ago, talk about dumb estate planning lawyer, was a little concerned about his health. He says, you think I need a will? I said, well, all your funds are with an IRA, right? He says, yeah. I said, all you need to do is put a named beneficiary in the IRA, and it won't go through probate, it'll go to your beneficiary. My brother, unexpectedly, passed away 2 months ago. Guess what? Never put a named beneficiary on his assets. So guess who's going through probate in New York State? Intestate probate with no will. So, moral of the story, check your beneficiaries and make sure you have a will, because you never know. Okay?
Can you have a contingent beneficiary on an IRA or an insurance policy?
The question is, can you have a contingent beneficiary on an IRA or insurance policy? Almost all of them are set up to take a contingent beneficiary, specifically for the reason if your primary beneficiary isn't there anymore, you don't want to be out of business, it goes to your contingent beneficiary. Same thing though, I urge you to check those every 3 to 5 years to make sure that you want your primary and your contingent to be the people or the organizations that you want. Okay? But once again, I'm going to restate it again because it's sort of important. What probate is anything that you die with in your name alone has to go through a court process. If you have a will, it'll eventually pass by the terms of the will. If you don't have a will, it's what's called an intestate formula, next to kin. So I hope you like your next to kin. All right, so that's what probate is. I know, before I move on to estate tax, does anybody have any questions on the probate piece?
Just one thing, Roger. What if the only thing in your estate that's still in your name is your automobile?
Okay, it's actually a good question. What if the only thing in your estate still in your name is your automobile, which, by the way, happens quite a bit. There's 2 levels of probate in Massachusetts. There's full probate when the estate is above $25,000, and there's what's called a voluntary administration, which I call a mini probate, which is below $25,000. So if you have what's called a de minimis estate, say you got a checking account with $10,000 trapped in it, you don't have to do a full probate. You do a voluntary, which is a lot less onerous. A lot of times, the car is the only thing that's in somebody's name. And usually those are handled under voluntaries. And even if the car is worth more than $25,000, you can still do it under a voluntary administration. But that happens a lot. It does happen a lot.
Should do cars then, can they be put in a trust?
You know, people don't put cars in trust. It's a good question and it's a logical idea. I've never encouraged it. It's a tough one, you know, because you don't really want a second name on it unless the second person is using it. But I don't think a lot of people put cars in trusts, and I don't urge people to do it. A voluntary administration, worst case scenario, is not that terrible.
If you're leasing a car, does that change anything? When you pass away?
If you're leasing a car, you'd own it. So usually leases have, you know, on death return, the family has the option to return the car. Okay, go ahead.
If you have a probate estate, don't you have to advertise in the paper to notify potential creditors?
There's 2 types of probates these days. One's called an informal probate, and one's called a formal probate. You know, Massachusetts had this probate system that worked fine as far as I was concerned. And in 2011, they went to this uniform probate code, which broke it down to these 2 things. You always have to put in the paper for the formals. For the informals, you're supposed to put it in the paper. Sometimes people do, sometimes don't, but I would advise it. For the formals, it's before the executor appointed. For the informals, it's after the executor's appointed. Where's the logic? No idea. Go ahead.
So let's say you have 2 or 3 cars. Maybe one is a classic car that's worth 30 or 40 grand, and you don't want to obviously go through all those situations. Could you have a notarized letter that just says, upon my passing, these cars would go to my son or whatever? Doesn't look like it from that.
Yeah, I you know, anything short of legal formality, I wouldn't tell you, yeah, you can do it, and then find out that you can't. So cars are a tough one. There's really no way around it. You think cars are tough, wait till you get to mobile homes. But anyway, that's a story for another day. All right. All right. Any other questions on probate type stuff? All right. I'm going to go on to estate taxes, which we're not going to talk about at length, but since it gets confused into the mix, it's worth talking about. Here's the main thing you need to know about estate taxes, and unfortunately it probably does apply to most of you. If your estate, with yourself as a sole individual or yourself and a spouse, has less than $1 million in it, including the value of real estate, including whatever you have, life insurance policies, if you hear the word estate taxes, don't think about it again, all right? If you have less than $1 million, you're not going to owe estate taxes, all right? Now, it's not that tough to have over $1 million in Eastern Massachusetts. If you have a home in the Sharon or Canton area, you're probably talking $500,000 or $600,000, all right? And then you add a couple of $100,000 to that, maybe life insurance proceeds, maybe IRA proceeds. It's all countable, by the way. All proceeds of whatever sort, whether they're probate or non-probate, whether it's in a joint account, is all countable for estate taxes, all right?
Excuse me, including what's in a trust?
Yes. Everything is countable for estate taxes. A lot of times people think, well, if it doesn't go through probate, it's not a countable asset for estate taxes. I've had several estates that have had to pay estate taxes that didn't go through probate, so the two are sort of separate. It's the totality of what you have when you die with stuff that's either in a trust, joint account, named beneficiary account, or in your name alone, okay? It's a $1 million in Massachusetts. That's the state level. The federal level is $5 million. For most people, that's not a concern. Massachusetts is talking about, I almost hesitate to bring it up, but what New York and New Jersey did recently, their estate tax thresholds were at $1 million. And to be honest with you, they were just losing too many people to Florida. So they raised their estate tax levels. Massachusetts has only begun talking, and it hasn't happened yet, and it may not happen, very recently in the last year about the possibility of raising the estate tax level to $2 million, which would help a lot of people. So don't take my word that it's going to happen, just that it is on the radar, and it has been on the radar for the first time ever, really. Go ahead.
Net or gross?
Gross.
It's
Well, no, there's some deductions, but the deductions are minimal. End-of-life expenses.
What about mortgage?
That's a debt. Yeah, you can remove, the question is, can debts be removed from your taxable estate? Yes.
Secured and unsecured?
I don't know. You got to check the UCC for that. I don't think it makes any difference, secured or unsecured.
But you can deduct both the secured and the unsecured.
I would imagine that you could, as long as it's a debt. It's the totality of your estate, total assets minus total debts, expenses, whatever. Okay? People talk about the annual $10,000 a year gift. I mean the annual $11,000. I mean the annual $12,000. I mean the annual $14,000. Okay, so people know it's $15,000 now. All right, it's been $15,000 for a couple of years. I don't know if it's going away. What makes sense to do there and how that works, if your estate is over $1 million, basically what you can do is you can give $15,000 a year to as many individuals as you want to try to knock it down. And if you have a spouse, each can give $15,000 a year. So if you have 3 kids and a spouse, you can technically give $30,000 a year to each kid to knock your estate tax level down. They don't have an inheritance tax, you don't have estate taxes, all right? If you're not over $1 million, it doesn't really make sense to do that. I mean, if you want to do it, fine. But if you're not over $1 million, it doesn't really make sense to do it. Go ahead.
You have to file gift tax returns annually when you make a...
Technically, you're supposed to, but nobody does. But nobody heard that, okay? And I never said it. Okay. Go ahead.
What occurs if you have a C corp and you're the only one? You have a real estate company who sells, and you have a car and you're the only person in that corporation. What happens?
Off the top of my head, I'm not going to give you an answer that I'm not 100% certain on. If you want to talk to me afterwards, I'll try. But it's more of a business thing. And most of these areas are personal, residential, personal, so on and so forth. Business is sort of its own entity. Okay. Go ahead.
You know what an irrevocable life insurance trust is? If you have a taxable Massachusetts estate with a significant amount of life insurance, do you advocate transferring life insurance to an irrevocable life insurance trust?
Well, the irrevocable life insurance trust is basically used to use your annual gift to fund something to pay estate taxes when you die. In other words, if the estate is not liquid enough to pay the estate taxes, the funds from the annual gift can be used. That's a whole other complex process. But
if you transfer the life insurance to the ILA, doesn't that take it out of your estate?
there's some question about that. There's some business about 3 years. There's some question whether it works or not. I tend to be very conservative, and I say not so much. Go ahead.
What's the tax rate on the $1 million or more?
Interestingly enough, it's just like taxes. It's a graduated rate. Here's the funny thing. If your estate is $999,000, you don't pay any taxes. If your estate is $1 million, you pay a minimum of $36,000 taxes. Because what happens is it kicks in at a lower rate and brings it up to that rate. I would say of the estates that I've done with estate taxes, they tend to run about 10% of the amount that's over $1 million. Go ahead.
My question is this, there's many advantages of paying taxes in Florida than there is state taxes than there is here. However, what disadvantages are there? If you lived in both places,
I can't really say that there are any disadvantages. You have to have proof of residency. Massachusetts will try to drag you back in. There's about 22 different indices of residency, so it's problematical. I have to say honestly, if you have a choice of living 6 months and a day in Florida and you qualify as a Florida resident and your estate is substantial enough, it might make sense.
how do they know that?
How does who know it?
State, how would they know? How would they know that with their 5 months?
It's a good question. I don't know. I don't know the answer. Go ahead.
There is a unit up in Worcester that checks on residency. And if you are trying to establish residency in Florida, you better live there 6 months.
Okay.
And you better have your money in banks in Florida.
Okay.
And you better have your clubs showing your residency in Florida. Because if you have documents that say you're living in Massachusetts, the state is going to come back and say you're a Massachusetts resident.
Yeah, this is what the gentleman said. I talked about there's like 22 different indices. When he says Worcester, that's where what's called the estate recovery unit is. Okay? All right, so it's, not all of this stuff is black and white. That's all I can tell you.
When they ask the question, how do they know? They can tell by your home, whether your utilities, your water. I mean, they can tell those kinds of things. If you're not using it, they could possibly tell.
Where your dog is
There's ways they can
licensed.
see that.
Okay, all right. So all good points. I don't know if people can hear the questions, but go ahead. Go ahead.
Other than the 6 months and a day, are there any other time requirements to move your residency?
I'm not aware that you have to be there for X number of years. I'm not aware of that. So I don't think there is. Okay, go ahead.
Question, if you have banks, say you're a resident of Massachusetts, and you invest in banks that are out of state, do you pay for the interest on taxes to the state?
I'm not quite sure.
If you had money in a bank in Florida, for example, but you're a resident of Massachusetts, does the interest rate you get taxable in Massachusetts?
I don't know why not. I mean, if you're in other words, if you're getting income from those accounts. you're a resident of Massachusetts and you're paying Massachusetts income taxes, and that's income, it would be income, even if it's in a Florida bank. All right, I'm going to move on to the scary area, Medicaid, nursing homes, protection of life savings. All right. Here's the thing to know about that. People say, if I have to go to a nursing home or my spouse has to go to a nursing home, they're going to take my house and they're going to take my money. Okay? That's not the case. They don't take your house or they don't take your money. They may take it by default, but they don't take it that way. What that basically means is if you have to go to a nursing home, you have to qualify for state assistance. And if you don't qualify for state assistance, then you have to pay the private pay rate. Let's talk about the private pay rate. Anybody know what nursing homes average in Massachusetts these days? About $12,000 to $15,000 a month. All right? A month, yes. So how do you pay for it? All right, people say, well, Medicare will pay for it. All right? Medicare is designed for what's called rehabilitative care. You have an accident, you have an injury, you're out in the community. They pay for getting you back up to where you were. At some point, you can't be rehabilitated through age, illness, or whatever, in which case you're classified by a medical staff as custodial care. And Medicare, designed for rehabilitative care, doesn't pay for custodial care. So you have to private pay, or if you have what's called long-term care insurance, which is like life insurance for a nursing home, you can do that. In most cases, that doesn't make sense. It certainly doesn't make sense for anybody who's 75 or older. Maybe if you have it in your 60s and it comes into play later, it makes sense. So for most people, that's not feasible. All right, so how do you qualify for Medicaid? State doesn't take your house and take your money. All right, if you have a spouse, this is what you're allowed to have. Spousal couple, the spouse not going to nursing homes, allowed to have a primary residence to live in, and roughly $125,000 of other assets. So it's not that they're going to take stuff, it's just that they're not going to pay for your care until you reach those levels. All right? What can you do? You hear these ads on the radio, which are legitimate, by the way. I'm not saying they're not. Is you can qualify for a nursing home for people with over $125,000, as long as it's not too excessive. Say you have $400,000. You can take a ball of those assets, say $300,000, and convert it into an immediate annuity for the spouse who's not going into a nursing home, so that instead of being at $400,000, you're under $100,000. The first spouse qualifies, the second spouse starts recollecting over time. All right? That's something that is a viable option for spousal couples. It's tough to go, in my opinion, even though technically there's no limit of how large an annuity you can get. It's tough to go over $300,000, maybe $350,000 of converting assets that way. The other thing I will tell you, and I've been doing this for over 20 years, is Mass Health is made up of many fine people who are doing a tough job. The problem is that there are way too many people chasing way too many dollars, way too few dollars, excuse me. And Mass Health is becoming increasingly difficult to deal with. If you try to qualify somebody for state assistance, it's very difficult. Even if you cross all your T's and dot all your I's, they're just giving in. We have a group, NALA, National Academy of Elder Lawyers, and we have a chat line, like a bunch of old ladies, no offense. And everybody's complaining about how they have this case that's legitimate, they've had all the proofs, and Mass Health is not allowing it. So not much encouraging news in that area. The other thing I'll say, and I get this quite a bit, is people say, well, my wife or my mother is going into a nursing home in 4 months. Can I make this $15,000 gift? Once again, the $15,000 gift is for estate tax purposes. If you do it for nursing home purposes, it's considered a transfer of assets, which picks up a 5-year disqualification period, which means if you have to go into a nursing home within 5 years because you've transferred an asset that could otherwise be used for your care, the state says, we're not going to pay for your care for 5 years. Okay? It gets worse. If you're down to a single individual, that person is allowed to have $2,000 of assets, and that includes the value of real estate. So if you have a house, unless you're living in a chicken coop, you're sort of going to be caught. And that's the situation. That's the situation where people lose houses. If somebody has the immediacy of going to a nursing home within the next year, the next 6 months, and they have a house in their name alone, this happens often, mostly with older women, that's where we lose houses. Yes?
What happens if you put the house into a real estate trust, and it's 5 years in advance of going into the nursing home?
All right, he asked if you put a house in a real estate trust. It depends on what kind of trust it is. I understand it's a real estate trust. All right, if it's an irrevocable trust and it's written the right way, and this is what scares me, and the house has been in there for 5 years, then the house is protected. It's as if it doesn't exist. But it has to be written the right way. All right, and written the right way means this, that when you put it in there, you and a spouse can have absolutely no benefit from that property. It's like you've given it up. You've given up what's called use and control. And one of the things that Mass Health is making it very hard on us is they're saying that all these irrevocable trusts, which theoretically meet the requirements, don't meet the requirements. They're very tough on irrevocable trusts. It's sort of a hot area. Go ahead.
You have it sort of bypasses the next generation and it goes to grandchildren or something like that neither of the principals benefit from.
Can you repeat that question?
The question is sort of like, that's like not a bypass trust. It's like a GST, a trust where the people you're giving it to also have no access to the principal, but only the third generation, the grandkids, have access to the principal. You know, I can't give you a yes or no answer to that because I don't think I've seen that case tested yet. I haven't seen that come up with Mass Health. Go ahead.
What happens if the house is homesteaded?
It's a good question. I'm glad you asked it. People ask about the homestead. The homestead is a very fine thing to have. For $37, it gives a lot of protection against creditors, Sears, Visa. It used to be $10, still a good value. What my concern about the homestead is people have false reliance on it. A homestead does not protect against any state, federal, or county lien. Does no protection for nursing home purposes. Still good to have, right, but it's not going to help you for nursing home purposes. Okay.
The question. Do you have to physically put the homestead, record the homestead? Or I understand recently that when you transfer property, the homestead is automatically placed on?
The question is, do you have to record the homestead or is it automatic? You have to record the homestead. A yes or no question, I like that. Come up with some more of those. Go ahead.
The means testing that they do for nursing home care, that's all federal, doesn't matter what state you live in, correct?
No, there is some variation in states. State differs. I don't off the top of my head know the particulars. Even though Medicaid is a federal program, states have variations within it. I can just tell you what Massachusetts is. Okay.
Can you put a homestead if you have a revocable trust on the house?
Yes. All right. Yeah, that changed several years ago. It was questionable whether you could do it. There's two sections of the registry. The registry of deeds, which is recorded land, and the land court, which you don't want to deal with, which is registered land. Land court never yet let you do it on trust before. Registry, you did it, but you didn't know if it worked. Passed several years ago, you can put homesteads on property that's in trust. Yes.
They say, I don't know if this is true, but you might know. If you have long-term health and you own a house, they cannot take your house.
Theoretically, if you have certain long-term health that meets certain requirements, the house is protected. Once again, that's something at this point not so sure about.
If you have long-term health, then you can't keep the house, and it's not in your, you don't have to pay, give it over to the nursing home or whatever it might be.
There are some policies to protect the house. There used to be a minimum. This is going back to 1999. I don't really even remember the particulars. It should give you some protection for the house. Go ahead.
The $125,000 above your house
Right.
limit you were talking about for a couple.
Right.
Variable annuity, insurance policies and all add to that 125, or are they?
Everything.
Separate?
Everything's counted.
Everything is still, because when you were saying you had an annuity, that would not, so it's once you've
If you,
activated an
If you get what's called a Medicaid annuity, if you take that ball of assets that's over $300,000 and it's an annuity that has certain requirements, it has to be for your actuarial life expectancy, it has to pay back at least what you put in, which it usually does, plus a penny. Annuity, a lot of people say, I don't want annuities, it's a bad investment. It's a good investment if it's the only thing that saves you from losing $10,000 or $12,000 a month. Okay, go ahead.
The annuity you were talking about before, is that subject to the 5-year look back?
You talking about a Medicaid annuity?
The annuity you mentioned a few minutes ago, to reduce the amount.
No, it's not. In other words, what you're doing is you're at 400,000, you want to get to 125. Right. It's basically, the idea is so that the spouse won't be impoverished. So you're decreasing your assets, the first spouse qualifies, but you're increasing their income so they can live comfortably.
So that's not counted as part of the 5-year look back?
No. Right.
My wife and I have had long-term care insurance for many years. Mm-hmm. We're not ready to go into a nursing home. Okay. But we might consider an assisted living at some point. Okay. Or someplace like Whitney Place here in Sharon. Mm-hmm. Would the insurance, the long-term care insurance, pay for the monthly rate or help pay for the monthly rate towards assisted living or other than?
The question is, will long-term care pay for assisted living? It really depends on the policy. Most policies have provisions for in-home care and certainly nursing home care, and it depends on the particular policy whether it has care for assisted living. I suspect that most do, but you'd have to check that particular policy.
I know somebody told me that their monthly payment is subsidized by the long-term care insurance.
It's only if there's 3 meals a day assisted living.
Okay, once again, it's pretty technical. So just a general answer for the group, you really have to check the policy. Go ahead.
Just because I looked at my policy establishes different rates depending upon if it's a nursing home, home care.
Okay, right, pays X amount per day.
But to tell you the truth, the policy has been in place in a long time. It will not cover the current nursing home charge.
Right. It's the way it goes. All right, so those are the dire statistics on nursing homes. What do I want to say? Protection of the house. All right. Go ahead.
There's been some talk that irrevocable trust, in order to save the house, may go to a 7-year look-back period. Do you think that will happen?
I haven't heard of it. I've seen it in advertisements for people who are selling stuff. It's 5 years. Once again, we have our old lady chat line, NALA lawyers, and if anything comes up, we know about it, and I haven't heard that.
From 3 to 5, though.
It already is 5. It went from 3 to 5 in 2006, but it could. But usually, it's like the estate tax thing. We hear chatter. We hear a little bit of stuff happening at the State House. There hasn't been any chatter on that. Okay. So the most valuable asset that most people have is a house. So how can you protect your house from nursing home? All right, gentleman said long-term care. Once again, open to interpretation. Irrevocable trust does work if it's written the right way, where you absolutely can have no access to the principal. And the principal can't be shipped back to you. They say, well, my kid can take the principal from the trust and give it back to us. Doesn't work that way. Most common thing people do is something called a life estate, which divides the ownership of the house between a current owner, who is you, or you and a spouse, and a future owner, who are your kids. Your kids have no current interest. So if they have a problem, it shouldn't affect you, just like it's sort of like a TOD for a house. It's not their current asset. But they do have a future interest. So if you decide to sell or want to reverse it, you need their okay. As long as you have their okay, there's no downside to a life estate. A life estate does pick up a 5-year disqualification period, but if you make the 5 years, the house, in essence, is protected. If you don't make the 5 years, and one of the spouses has to go in, the house can always be put back into the name of the spouse who's not going in, and you haven't lost anything, you just haven't gained what you otherwise would have. So it's not really a bad thing to do in most cases, if you trust your kids. I've probably done 2,000 life estates. We've had to reverse about 20. It's in the kid's interest to do it. I've never had a problem with the kid going along with that. So that's something that I do want to mention there. So I think that's, I feel like Forrest Gump. I think that's all I'm going to say about that. Unless anybody has any questions on the nursing home piece, I'll move on to the final piece. Go ahead.
If you have a life estate and you go into a nursing home and the house is sold, do the kids get their percentage?
If the question is, if you have a life estate and the house is sold, do the kids get their percentage? If they've been on there for 5 years, in essence, they earn credit, and you could parse out their amount. It's based on an actuarial table. But if it's less than 5 years and you give them money, that's a transfer that will pick up a 5-year disqualification period. Make sense? In other words, if you want to give the kids money from the house, make sure they're on there for 5 years. They're on there for 5 years. They're on the deed for 5 years.
So if they're on the deed for 5 years.
Right.
And the house is sold, they would get their share.
If you chose to give it to them, yes. Without it being a penalty for Medicaid or Mass Health.
This is just a comment and not a judgment.
A comment and not a judgment.
Okay.
From the peanut gallery.
People should understand that Medicaid is Title 19 of the Social Security Act, and it is a welfare program intended to pay for people who can't take care of themselves. And you do what you want,
Right.
and whatever is legal you can do,
Right.
but you should know that what you're creating is a welfare program for yourself.
All right, I can't disagree with that. On the other hand, somebody can make the argument, and I'm comfortable with, if a spouse is going to be left with $125,000 and they could otherwise have $400,000 and they have 20 years to live, is that so terrible?
But there's a lot of the times when we're not talking about a spouse anymore.
Okay.
Some of us.
Then the annuity doesn't matter because it doesn't work for a single individual. Go ahead.
Could you define a life estate, how it works?
Basically, my definition of a life estate, it's making the house have a current owner who is you and a future owner who are your kids. In my opinion, it's just like a TOD or POD bank account. You're the current owner. The kid has no interest until you pass away, at which point their interest vests, or until you sell it, and it's been 5 years, you can give them, parse out a certain amount of assets.
Do you have to record the life estate within the deed?
A life estate is a deed, yes. Okay. We've been taking a lot of time, so I think I'm going to try to wrap up here. All right, so I have at the bottom of the page actions to take or consider taking. All right. Documents, everybody should have what's called a standard core estate plan. There's actually 5 documents, 2 that are financially based, 3 that are medically based. 2 that are financially based, first one's a will. Will says when I die, this is what goes to who. All right? Even though you don't think you may not need a will, like my brother didn't, everybody needs a will. If a person becomes legally incapacitated and can't make financial decisions, somebody else can't automatically do that for them. You got to go to probate court and get what's called a conservatorship. There's a document called the durable power of attorney where you're pre-appointing somebody to act for you, usually a spouse, and also usually an alternate who's a child. So that if you become legally incapacitated financially, you don't have to go to probate court and get a conservatorship. The other 3 documents are medically based and go hand in hand. Healthcare proxy, legal appointment of a healthcare agent. Without a valid healthcare proxy in Massachusetts, somebody would have to go to probate court and get a guardianship. In Massachusetts, just because you have a healthcare proxy, the medical institution doesn't have to act in any particular fashion. Companion documents called a living will, which is a statement from you yourself that if you're vegetative comatose, no chance of recovery, that you wouldn't want to be kept alive artificially. I don't know if anybody remembers that lady down in Florida, Terry Schiavo, the woman in the coma. What that was all about is she had a healthcare proxy naming the husband, but she had no living will. So the medical institution said, fine, we see you're the agent, but where does this say this is what she wants to do? And that's why that was such an ordeal, and that's why those documents go together. As if that wasn't enough, The federal government passed something called HIPAA, Health Insurance Portability and Privacy Act. So now if your agent needs access to your records, you need to sign something that basically says, hey, if my agent needs access to these records, I'm aware of HIPAA and I'm authorizing him or her to have access to those records. Between those 5 documents, there should be no situation that comes up that if you pass away or you become legally disabled for health or financial purposes, that you haven't pre-spoken for. I mentioned at the very end some other things that may be relevant. Living trust is relevant for avoiding probate, is relevant for estate taxes if you have a taxable estate, is of no benefit for Medicaid or nursing home purposes. Life estate we talked about, and I think that's where I'm going to start now. There is an organization of elder law lawyers called NALA, so if you're looking for a lawyer specifically for this type of thing, make sure that they're associated with NALA. That means that you should have some awareness in this. The other thing I want to say, somebody asked me about how do you know if your lawyer's been disciplined? There's something called a Board of Bar Overseers, BBO, and they have all discipline listed. So if you want to look up a lawyer and see if there's any discipline against, I'm only mentioning this because somebody requested it specifically, so I say. Yeah, BBO, Board of Bar Overseers. I haven't been disciplined yet. All right, so that's what I got. Hopefully this information is helpful. If people have questions, feel free to come up. We'll be here for a little bit, and I appreciate you coming down and listening.